The judge's role, the judge is focused on determining what is going to go before the jury, what's not going to go before the jury. I just copied here the two evidence code sections and I'm focusing, I will say, on California law, California state law. So the two evidence code sections that we are very concerned about is evidence code section 801, which talks about, first of all, the fact that you're only going to allow an expert to testify on something that is sufficiently beyond common experience. So sometimes you have things where people want to present expert testimony, but the judge determines, hey, that any juror could figure that out for themselves, so that's something to be aware of. And then secondly, it has to be based on matter that is of a type that reasonably may be relied on by an expert. And that's where Sargon gets into those issues. And then evidence code 802 talks about the expert talking about the reasons for their opinion and what they relied upon, which we'll get to that a little bit more as well. So Sargon, in short, I would say, established the principle that the court does play a gatekeeping function and has to exclude expert testimony that does not meet certain criteria. We'll talk about what those are. The basic facts of Sargon, for those who are not familiar, it was a breach of contract lawsuit. The plaintiff was a small dental implant manufacturer, and the defendant was a large university. They had a contract for the university to do clinical trials of the dental implants. And the plaintiff had a sort of a marketing and growth strategy based upon the clinical trials. They would, demonstrate how wonderful the technology was, plus there would be all these new dentists who knew about it, and so they would be using it. And things broke down, as things do. That's where the lawyers come in. And so they were suing breach of contract. We won't get into all the other issues that were at issue, but the central issue for purposes of the experts was the lost profits item of damages. And I will say, although Sargon obviously is a civil case, the principles apply in all areas, including in criminal. So the proffered expert testimony on lost profits, the expert sought to use a market share methodology, and the expert said that he had studied extensively the dental implant industry and determined that there were certain market drivers which determined how much market share you would have: innovation, clinical studies, and outreach to doctors. And on the basis of that, he compared the plaintiff to market leaders in the industry, and then came up with the conclusion that depending on how innovative the jury found this particular technology, that would determine the amount of market share. So, for instance, if the jury believed that the technology was revolutionarily innovative, then he believed that the company would get 20% of the market share, and you could calculate what the lost profits would be based upon that. If the jury found that it wasn't quite as innovative, less of a market share and less in terms of the lost profits. The rule that was established in Sargon is that, pursuant to the two evidence code sections that I cited, the court has to act as a gatekeeper and exclude expert testimony that's based on matter that is of a type that an expert may not reasonably rely, or based on reasons that are not supported by the material relied upon, or that are speculative. In the case of Sargon, the first one wasn't really an issue. The matter that the expert was relying upon were market studies and sort of standard ways of studying how an industry operates. But the problems came in with the reasons and with the speculative nature of some of the conclusions. And Sargon made it clear that the judge is not deciding between competing expert opinions. The judge is also not to determine how persuasive a given expert opinion is, but to quote the case, the court conducts a circumscribed inquiry to determine whether, as a matter of logic, the studies and other information cited by the experts adequately support the conclusion that the expert's general theory or technique is valid. So in Sargon, the court eventually found the market share methodology, that was valid. Using the market studies, that was valid. The problems came in with, first of all, the trying to compare the plaintiff, which was a very small company with like 1% market share, to the 6 market leaders. They weren't similar on any metric that one would use in the field. their revenue, their employees, their size of their R&D, none of that compared. In addition, although, as I described, the expert indicated that one could determine the amount of market share based upon the degree of innovativeness, the expert wasn't providing the jury with any criteria to determine whether a given technology was revolutionarily innovative or just a little bit of innovation. So that sort of invited the jury to just guess. And then finally, the court found that the assumption that even if the technology was extremely innovative, that would make this small company become one of the market leaders was essentially speculative, because you ignored the idea that the other market leaders would maybe come up with additional technology, or they would do things once there was competition in the market. So, excuse me. So for those reasons, the court determined that it was appropriate to exclude this expert testimony. So that's Sargon. Yes, and if it's all right, I know that we want to have a broader discussion. I'll just run through these quickly, and then we'll kind of get to the broader discussion. But I would love to answer additional questions. And so People versus Sanchez, this is a criminal case, but it applies in a number of areas, and that this establishes, essentially for our purposes here, the principle that the expert must not testify, the judge must not permit the expert to testify as to what's called case-specific hearsay. And so let me give you the basic facts on Sanchez. Mr. Sanchez was charged with a number of crimes: possession of a firearm by a felon, possession of drugs while armed with a firearm, active participation in a criminal street gang, and commission of a felony for the benefit of a criminal street gang. And the proffered expert testimony in Sanchez was one that was commonly used in gang cases. There was a detective who testified as a gang expert. He had been working with gangs, and he testified as to how do gangs operate, and the specific gang that was at issue, how this gang operates, what their modus operandi is, what areas of the city they operate in, etc. And then he testified, this is where things got a little tricky. He testified with respect to these step notices, which are, step notices are essentially the police, when they are doing gang enforcement, and they see a person A associating with a known gang member, they will have a conversation with that person, and they document the conversation where the person, in this case, Mr. Sanchez, acknowledged that he associated with known gang members. But what's important is that although this individual the expert was a detective who studied gangs and worked in the gang area, these step notices were not anything that he was personally involved in. They were all other police officers having interactions with Mr. Sanchez, where Detective Stowe was not personally involved. And then the FI cards, field identification cards, those are also, let's call it a mini police report about an individual's contacts with a gang. And again, these were not reports that this detective had authored or had any personal knowledge of. And so the rule that was announced in Sanchez was an expert is, of course, permitted to testify as to general knowledge in his field of expertise. So when this expert was testifying as to how gangs operate, there was no problem with that. Then an expert also can testify as to specific matters of which he has personal knowledge. So this detective could talk about his knowledge of this gang and how they operated. He's not permitted, however, to testify as to case-specific hearsay. And so the step notices and the FI cards that I mentioned were hearsay. They were documents prepared by other police officers. This police officer did not have personal knowledge of Mr. Sanchez or any of the things in the notices. So the prosecution would never have been able to just present those documents in court. They would clearly have been excluded as hearsay. But up until this time of Sanchez, you could sort of get them in through the expert. The expert would rely on them, and the argument would be the jury is not supposed to take them for the truth of the matter. The jury is just to hear the hearsay for the sake of understanding what the expert relied upon. And that's what the Sanchez court said is untenable. If the expert is relying on these facts and you're asking the jury to believe the expert, it is unrealistic and basically impossible to also say to the jury, well, don't treat the facts that the expert relied upon as true. And then finally, that Sanchez did say that the expert is still permitted to rely on the case-specific hearsay and testify in general terms that he did so, but he just can't relate the details of what was in that case-specific hearsay. So that's what makes things a little bit tricky, I think, both for all of you and for us as judges. There's another issue in Sanchez which I'm not addressing, which has to do with testimonial hearsay. I think it's probably better if we just focus on the fact that case-specific hearsay is now clearly excluded. And then I would add, with respect to Sanchez, Sanchez makes it clear that the expert can testify with respect to hypotheticals, but it makes it clear that if the facts that are in the hypothetical have to either be facts that can come in that are subject to a hearsay exception or some other reason, or there's another piece of evidence that can get those facts in. So in the case of Sanchez, the prosecution could have called the other police officers to say, I spoke to Mr. Sanchez, I saw him associating with a known gang member, and then the detective could have given his opinion based upon those facts. And so essentially, if the party can't get in the facts through a hearsay exception or some other means, the expert isn't going to be able to sort of get in, the party is not going to be able to use the expert to kind of backdoor these facts in that they can't prove up another way. So to conclude, I've just sort of listed here what we're looking for as the judge in terms of what flags go up that need to be excluded is expert testimony that's not of a type commonly relied upon in the field, based upon reasons that are not supported by the material that was relied upon, things that are speculative, case-specific hearsay, and then we talked about this a little bit in the beginning, not beyond common experience, or otherwise not helpful to the jury. Sometimes that's a little bit of a catch-all, but that covers where, for one reason or the other, this expert testimony is not going to be helpful to the jury. Sometimes it's too confusing or some other issue. So with that, I will conclude, and I don't know if I should take your question now or we'll jump back to our moderator.
Why don't you go ahead?
Okay.
So we don't forget it.
Okay.
Well, my first question is, I've only testified 4 times in trial, and they've been bench trials. So I'm not exactly sure what determines whether something ends up as a bench trial or a jury trial. I guess that's my first question. And the next question is, how does the judge know ahead of time what the expert's opinion is? Are they just reading a trial brief, or where do they get that to determine what can be discussed in front of the jury and what can't?
Perfect. That's a great question. Very practical. I'll talk about it a little bit from my perspective, and maybe my colleagues on the panel can pop in. With respect to whether something is a bench trial or a jury trial, sometimes it is the discipline, the specific discipline, and sometimes the parties can agree to it. In criminal, for instance, everyone has the right to a jury trial, but if both sides agree to a bench trial, they can. And the same is true with certain areas of civil, so I hope that helps. And then with respect to how does the judge know what the expert is going to testify about, broadly speaking, in every area prior to trial, there's something that happens prior to the trial starting where the lawyers are presenting to the judge whatever their concerns are. So in the civil context, there's usually a hearing before the day of trial. And so what would happen, practically speaking, let's take something like a criminal case that I would handle, and switch to criminal for a second, or even in civil I've seen this. Before the trial, so I'm sitting there with the attorneys, we're getting ready to start the trial, and one side says, Your Honor, he wants to present expert testimony of this expert that should be excluded for XYZ reasons, and he explains it to me. And the other side says, no, our expert should come in for these reasons. So in short, there's going to be some form of hearing before the trial. It might be the day of the trial or days before or weeks before, and the parties are going to present their issues. So it's typically not
motions in limine?
Motions in limine, exactly. It's typically not, although I described what the judge has to be concerned about, and certainly if I'm in the middle of a trial and I see something like case-specific hearsay, I might jump in. Generally, I'm waiting for one of the parties to raise the issue. I'm not going to independently interpose my own objection. I don't know if you want to give a little bit more.
I can say a few more things on that. Most of us are talking about state court. Actually getting in front of a judge 4 times is actually a lot. It is a lot, because most cases, you give your deposition and it's over. In federal court, we exchange what we call Rule 26 reports that have every little, the idea of Rule 26 reports is you'd never have to depose an expert, because the report would contain everything. And that's a discipline unto itself. I know, Tim, you do them a lot. They're a lot of work, but once they're in the can, you're kind of on easy street, it's done. Now, the motions in limine, there are a number of different names for what they are. It's where we tackle the big expert issues, but not always the small ones. So trial is kind of, it can be exciting. The rules of evidence are the same, whether there's a jury or a judge. And typically, the way it happens in a fast-breaking trial is the jury hears the evidence that the judge then says you have to disregard that. But the big issues everybody knows about. Does this expert have a qualified opinion on causation? Is he relying on the right kind of things to formulate his opinion? Is he using the methods of science reliably? That's what we go to the court on a Daubert motion, for instance, in federal court. You've all heard about Daubert from me. Or a Kelly Fry motion, which only applies to newer novel evidence. Kelly Fry gets a lot of press in these kinds of meetings, but Kelly Fry applies when an expert is coming up with something new or novel. But for real estate appraisers, they're doing what real estate appraisers have been doing decades. They're not going to get into that. The kind of thing a real estate appraiser or an engineer might get into is he relying on the right kind of information? So we'll have tried the big issue on a motion on whether this guy's got the qualifications and he's relying on the right kind of stuff. But you're going to be sitting in the box and you're going to be doing your damnedest to get hearsay and evidence, or to have an opinion that is beyond your official realm of expertise. And that's when the fireworks happen. My opposing counsel leaps up and we all get hauled up to the sidebar, and the judge has her court reporter come around. It's all very dramatic, and the court reporter comes around. You've been through this too. Everybody that's been in front of the jury has been through this, and we all whisper, and the jury wants to know what we're doing up there. And then we all go back in our places, and the judge says, "You will disregard the last question," or "Objection overruled, please proceed." So that's kind of how it goes. You usually have an idea ahead of time, and Mr. DePew is also going to talk to you about ways to predict those little fireworks shows and how to deal with them. It's fun. Can be admitted through an appropriate witness, and the expert may assume its truth in a properly worded hypothetical question in the traditional manner. What is a hypothetical question? It's what we all do when we're putting on experts, almost all of us, and Mr. DePew will take you through one. But what we do is we ask the expert to assume the following facts, and we have a list of facts on which he will formulate his opinion. And we will have already introduced every one of those facts in evidence through a witness that is qualified to give it, which is what you're talking about. The plaintiff already had offered all of those facts. So when the hypothetical then is laid out, all the facts are already in evidence. Sargon says that is perfectly appropriate. That is the way to get hearsay into evidence. What is not appropriate is to load up the expert with a bunch of hearsay that no witness is coming into court to talk about, and tell the judge it's not really hearsay, it's expert knowledge. Because it isn't. It's trying the defendant on hearsay, on out-of-court statements offered to prove that they are true. And the court said that violates the confrontation clause because it happened to come up in a criminal setting. A defendant is entitled to confront the witnesses against him, and by offering hearsay that way, he doesn't get to do that. So that's really the reason for hearsay in the first place. So what you said is exactly the right way to do it, and that's exactly what Sanchez says you do. You put together a hypothetical.
Okay.
So we'll go to the next part, which is preparing to testify, which you'll all have done many times. And I would like to ask Attorney Brian DePew to weigh in on some of these things. One is the attorney clearly defining the expert's role and giving the expert a clear assignment. Did you want to talk about that, Brian?
Yep.
Yes.
Yeah. So could I see a show of hands of everyone here that has testified in a deposition or a trial as an expert witness? Wow, okay, that's almost everyone here. So what I'd like to do is focus on the practical how-to. And today's overall topic was how to protect the expert and their testimony and deposition in trial. So how do you do that? Typically, when you're an expert witness and you're being cross-examined, you've got a notice of deposition or you're being called into court to testify and you're being cross-examined, the latitude of the cross-examination is completely different than when your own expert is doing your direct examination. In cross-examination, either in deposition or trial, that opposing counsel can ask you leading questions, and that's a whole art in itself. So, is everyone here familiar with the difference between a direct examination question and a cross-examination question, which can be leading? Does anyone have any questions about that?
Can you give an example?
An example is, if you're testifying, for example, as a fact witness on direct examination, you can testify to who, what, where, when, and why. If you're an expert, you can testify to expert opinion, and opposing counsel is allowed great latitude and can ask leading questions, which means, Dr. So-and-so, isn't it true that the treatise that you relied on says nothing about what you're saying? Isn't that true? That's a yes or no question. And he can do his entire cross-examination at deposition and trial and never once ask you a question where you're allowed to explain yourself or you're allowed to go on with what your testimony was in your report, if you prepared one. So you as an expert, when you walk into a deposition, are now, rather than being the knowledgeable expert who's been informing you, the attorney who's retained you, you're now suddenly being challenged by yes or no questions. How do you handle that? Well, one of the things you do is every time he asks you a yes or no question, you can always answer, well, not exactly. And now they're going to try to say, no, I want a yes or no answer to my question. Listen very carefully, and if you stick to your guns, you can say that question is too complex or it's incomplete in a way that I can't answer yes or no. You can typically get away with this in deposition. It's hard to do in trial because judges will make the decision that you may have to answer a yes or no, or you can answer yes or no, but I need to explain. Sometimes the judge will allow you to explain your answer in the cross-examination, but sometimes the judge will say, no, you can explain when your attorney comes back for redirect. So be prepared for cross-examination is all yes or no questions. I've done depositions and cross-examinations in trial. I never once asked a question that can be answered with anything other than a yes or no. And what seasoned good experts will do is they'll know that's coming and they will immediately launch into an answer, and you have to, what I do is I stop them and say, that's not what I asked you. So you have to be prepared for being pinned down to yes or no answers and how to avoid being pinned down by sticking to your guns, and it's not exactly yes or no. It's the best way to get out of it. So you're an expert, you've done your report, you've met with your attorney, and you get a notice of deposition. It's going to come with a request for production of documents. That means your files, your time records, and your emails. Watch out for emails. I've seen emails produced, and sometimes it's an exchange between the expert and the attorney about the substance of what he's saying. And sometimes the expert will ask, well, gee, what if I say this or that? And then the lawyer says, no, oh my God, whatever you do. Watch out for that. Emails are limited to one subject and one subject only with an attorney. Scheduling. Everything else is done on the phone or face-to-face. This is how you avoid getting into trouble. So, attorneys are allowed in cross-examination to ask you hypothetical questions. I want you to assume the following. Now, you've testified on this construction defect case that had it been properly sealed from the weather and there was no water damage in there, that this dry rot would have occurred over a certain period of time. I want you to assume the following. Well, almost in every single one of those cases, that hypothetical is incomplete. And you are entitled to a full question that's comprehensible and not have to guess. So when you're being asked those questions in cross-examination and it's a hypothetical, don't you do the work and fill in the gaps that are missing. Don't you do that lawyer's work. You ask the lawyer, say, well, you're entitled to my best testimony, correct? And he'll say, yeah. Okay, well then you're going to have to help me understand your question. You're not explaining to me this or that. And you make him do the work, and while he's doing the explaining, you're almost developing your answer to his question. Rather than you thinking, oh, I've got to have an answer like this. If I don't have an answer to his hypothetical, I'm not going to look good. Make him do his work. Ask him, say, well, you're hypothetical, I'm not sure what you're getting at. Do your own independent research. Many times, attorneys will like to do all of the research for the expert and hand them a file. Do your own independent research. You could say, yes, I got some reliance documents for the attorney. I thought it was very interesting, but I always do my own independent research. That way you don't look like you're being spoon-fed anything. One of the last things is never allow the attorney to prepare a script for you. Sometimes in their insecurity about being able to elicit the testimony they want from an expert, they'll prepare little questions and answers for you. Avoid it at all costs. You can work all of this out with the attorney ahead of time. You can do practice sessions. I've done it many, many times. I've done it with Joe. We sit there and have these back and forth, and it's actually very educational. He gets an idea of where I'm going with what I'm going to ask, and I get an idea of where he's going with his answers. But don't allow yourself to fall into a script of having a lawyer say, well, I'm going to prepare a script for you. It's deadly. Understand, and this is my last comment, understand that the object of your cross-examination at deposition and trial is to A, discredit you, and B, exclude your testimony. So the way they do that is A, your methodology is flawed, or B, the documents or data you relied on are inherently flawed or incomplete. So it's going to be your job to be able to articulate your methodology, and a methodology that can be referenced in other journals in your trade or field, and all of the documents and data that you consider are the same types of data, research, and documents that experts in your field would rely on. That's what they're going after, your methodology. That's the pay dirt for exclusion. That's the gatekeeper. The judge right there is listening like this and thinking, and what's going in that judge's mind the whole time? Gee, is that the right methodology? Is their thinking logical? Is there a logical leap there? Oh, wait a minute, that research they relied on, that doesn't really say that. That's what the judge is doing. So you want to make sure you've worked that out ahead of time before your deposition and the trial. Anybody else? So I've got a little bit of, it's like a punch list. I didn't go over all of it. I'll leave some of it up here if you want to grab copies. I just made extras because I knew I wouldn't get through the whole list. I could spend hours talking about just this topic.
Counsel, Joe?
Yeah, go ahead.
There's, relative to the being pinned down with the yes or no, I testified one time and it was getting pinned down on the yes or no. That would be totally misleading the jury, and I stated that immediately, that I would be misleading the jury if I answer yes or no, and the judge allowed me to expound.
Yes. You've got a good judge. Well, a good judge. Let me just explain. I had just the opposite experience. I had one of my experts up on a witness stand in a trial, and it was one leading question, yes or no question after another, and my expert's going, I want to explain, isn't it true, sir, that this journal article says just the opposite way you said? And then well, yeah, but let me explain. And the judge was, nope. was infuriating, so I had to go back through in my redirect examination. Now, remember when you tried to explain to the jury and the judge wouldn't let you? Would you like to do it now? And yeah. So, but sometimes judges say, that's too much. Let's get through the trial. They're practical. They want to keep things moving. They say, yeah, give me your yes or no, and then explain or qualify however you want. You don't know. There's no set rule. It's not written in stone anywhere. But at deposition, you won't have a judge where you're kind of trying to say, your judge, I'm trying to get through this efficiently, like you were trying to do. And you're going to be pinned down. So what I found is something closer, approximate to not exactly, because there are these nuances. Just say not exactly. No, it's not exactly a yes. No, it's not exactly a no. And if I can't explain, then you're going to get the wrong testimony. And I'm entitled, because like he wanted to at the beginning of the deposition, he says, I'm entitled to your best testimony. You say, well, that's what you want, isn't it? Well, I'm entitled to give it to you. Yes.
So during depositions, some of the attorneys that I've worked with have been really good with objections and things like that. And other times I'm sitting there and I'm getting an incomplete hypothetical. I can't answer it like that. I'm not getting any objections. I don't know what they're doing, reading their phones or what have you, but they're not paying attention. And when I've said, that's incomplete for me or this or that, they're saying, hey, you're not allowed to. I've been chastised for it. You're not allowed to make, objections. That's the attorney's job.
Right.
So how do I handle that as an expert?
Right. So you don't say that's an incomplete question. You would say, it sounds like a hypothetical, but I'm not understanding your question. You're going to have to fill some stuff in for me, because if I answered it the way you phrased it, my answer may be incorrect. So no, I want to make sure you have a right to understand the question. Again, remember at the beginning of your depositions and say, if you don't understand a question, stop me. Well, now you're going to hold the attorney to it. Turn the table on him and say, no, you told me I was entitled to, you were entitled to get my best testimony. Well, I want to understand your question. That's the way you do it. So don't use the jargon of incomplete hypothetical. Just say, I need to understand your question, something's missing. And if you can, as an expert, think of what that something is, do it. I had an expert I've worked with many times. I think I'll mention this later. He's a brilliant guy. And one thing he was brilliant at, when somebody would ask him these very complex medical questions, he was in no hurry at all. I think you're going to have to. Well, he said. Well, the lawyer would say, well,
exactly.
what's missing? He said, well, you didn't explain to me in this hypothetical you're explaining. He would go on with what it is. He would think of something. And I'd say, okay, let me rephrase the question. And he would rephrase the hypothetical and he'd add that element. He'd go, oh, okay, I think I got it. And then he'd go, there's another thing that he would do this. He would go on forever. And so he was brilliant at making the lawyer do the work. He didn't do the work and say, oh, I think I know what he's getting at. That's really, you're doing his job. Another thing where they put documents in front of your journal articles, like many of you rely on journal articles. Well, have you read this document? Right in this paragraph, it says this. I want you to read that. The same expert say, oh, well, I have to read the whole document. And he'd say, okay, I'm going to read the whole thing. And so it's about 18 pages, highly technical. And he'd start to read it. He says, no, I want you to read this during the break. And he says, no, but the break is my rest time. I'm going to read it right now. And he'd sit there and read it. And finally the lawyer said, okay, forget it. I withdraw the question.
They're paying. The other side is paying.
Right. So he said, I don't do work on my break. So he'd say, let me study the entire article. And he would sit there for 20 minutes. And finally the lawyer said, oh, forget it. So you can control the situation and understand what the goal is, and the goal is to exclude you if you're testifying on behalf of a plaintiff. If you're a defense expert, your goal is to punch holes in him. That's all you're there to do, so that lawyer can say, oh, you're talking to the judge now, flawed methodology. The data that they relied on is incomplete, or it's not the right kind of data, or it doesn't really say what they say it is, or they're extrapolating way too far. The leap is too great. Anything else?
Yeah, I had a question about the idea of a script. And, this is post-deposition, right? So all the discovery is over with. I frequently use a script before trial because we're putting on a show basically, and I want to make sure that we're on the same page. I prefer to write it, but it's something that we share, we go back and forth because we want to make sure that once we present that we have a really cogent together presentation for the jury. Why is that a bad thing to do before trial?
Before trial, well, at that stage, the circumstances for discovery of that kind of script are extremely limited. Unless, for example, you have given your deposition testimony and circumstances have changed, and then they redepose you later, maybe on the eve of trial if there's new data or information. So what you're playing is, you're playing this risk that they're not going to have a second crack at getting to you. And having them, I mean, most good lawyers, when they were cross-examining you the first time or the second time, they're going to ask you about your conversations with your attorney, and did he propose answers to you? Did he suggest this? Are your ideas in your testimony, your opinion, are they being developed by you, or are you simply repeating what the lawyer is? So it's okay for you to work out what it is and then basically explain to the lawyer, look, you've got to cover these things with me. That's fine. But what I'm worried about is, especially in the deposition situation, where somebody has prepared a script and it's being sent back and forth in email, it's a disaster.
Yeah,
And
I
I've
mean, I
seen
would
experts' careers ruined
Right.
because they did this, and then every time they show up at trial, the opposing counsel says, oh, remember that case where you had this script prepared? They'll use it every other time. One last topic. If you've been deposed before or testified before, be prepared. They're going to get that prior testimony in your deposition and in your trial and say, well, isn't it true that you said this in this other case? So you should keep copies of all your transcripts and be familiar with it, and remember, you don't want to get sideways with positions you've taken previously.
How do lawyers get that information? I mean, is there data where they just enter your name in and all your past depositions come
Well,
up?
in federal court, they can ask you to list all your prior testimony for the previous 5 years.
Yes, I do
Is
want
that
to
Rule
say.
26? Is that what you're
Yeah,
talking
I
about?
wanted, you're ahead of me, I just opened up Rule 26 because I wanted to point out one difference between state and federal court, and you need to be sure your lawyer and you are on the same page with this. In federal court, we, about, I want to say 10 years ago, the federal rules started protecting attorney-expert communications. So draft reports no longer are discoverable in federal court. And it's been my experience in big cases in state court that everybody gets on the phone. You don't even do reports in state court. But typically in a big case with the judge having all the parties firmly in hand, the judge is going to say, you know, you folks are going to do reports, you're going to do them on a timetable. And then the parties all get together and say, are we going to do it like federal rules, that is, no discovery of drafts, or are we going to go by state rules in which all the things that all the horribles that Brian was talking about will happen? Every communication you've had with the lawyer will be out there. Now, the other thing he was talking about, prior testimony, it's out there. And why is because Lexis buys it, and Westlaw buys it, and I probably should have done this. I should have picked one of your all names and put them in the system, and I would have had all of your Rule 26 reports.
They create databases and lawyers network.
There's CALA, the Consumer Attorneys Association of Los Angeles County, CAOC. We have huge data banks of everybody's expert depositions. The defense people do the same thing. So all your prior depositions are out there and available instantly.
To answer your question about consistency, if you say the same thing whether you're plaintiff or defense, you don't have to worry about what you said in the deposition.
It's true.
Okay, I think that's generally true. I'm more worried about in this situation where if you're in a particular field and there's something fundamental to your opinion, it's a fundamental principle that, say you're a neurologist, and a neurologist would always do a certain test to try to rule in or rule out a certain condition, and it was a specific test. You'd say, well, yes, for this particular condition, one of the things you would always want to consider is this test. And then in the next case, it's the same, similar, closely similar fact. You say, oh no, God, you would never use that test for. suddenly, it's a sort of a fundamental issue. It really looks odd. Now, obviously, opinions can take different shapes and forms based upon the facts of the case. That's perfectly fine that you reach a different conclusion because the facts underlying the opinion are unique and different. But just so long as you're not taking some underlying principle to whatever your field is, you want to really make sure that you kind of hang on to those. Again, that has to do with the strength of the admissibility of your opinion. You're hewing to fundamental principles in your field. Yeah.
I had a situation once that completely shocked me. We submitted a very elaborate opinion on a trade secrets case in New York State. And they came back, and there was a lot of teaching as to the technology behind the conclusions. And they said, oh, that's all common knowledge. And I said, how can they possibly have computer technology intensive stuff and say it's common knowledge? And one lawyer proffered this explanation, and I want to get your opinion on it, is, in New York, they always throw it out the first time, and if you're serious, then your lawyer will bring it back in. And they always throw it away the first time. Is that really true?
Well, give me the context of the litigation. What was that the issue?
Well, there
was
were
it patent, trademark.
It was basically they ripped off some trade secret technology having to do with credit union financial transactions, and it was an important intellectual property item because the admission to get into that business, particularly in the New York area, was that you already been in it. So unless you could show that this technology had been used in a realistic credit union environment, it just, and you had a lot of explaining to do.
Yeah, this is a kind of unique situation because you're caught on the horns of the dilemma in a trade secret case,
Yeah.
where their defense is going to be, what's secret about it? Everybody knew it. That's their defense. So the burden is whoever's seeking to defend the trade secret is going to have to build that case around it's not common knowledge and it's unique to whatever the industry is or their unique actual business. That's really the dilemma that you're in. The battle of, everybody knew that. What can you do? I mean, that's just inherent in that kind of litigation.
What's the difference between a declaration and a report?
It depends on the circumstances. Reports typically in federal court are mandated as part of the procedure where you prepare a report and actually, I think Betsy just went through some of the criteria. It tells you the format of the report, what needs to be in the report. And a declaration can be something that, now we've done these many, many times where the defense or somebody will say, well, this expert did that, and I'll have to go to my expert and say, gee, can you explain this, if it's really complex or something. I said, I need a declaration from you where they said that you didn't account for something, and in your declaration, you did in fact you accounted for this erosion ratio that you used. It was accounted in your formula, and explain it. And so they would sign a declaration that they've read the criticism and know it's not correct, I did account for it, and you sign it under penalty of perjury and you give it to the judge.
In civil court, a declaration is an affidavit. The code says they're one and the same. And an affidavit is sworn testimony and it suffers from perjury. In federal court, when you do a report under Rule 26, as you've asked, Rule 26 requires that the reports be signed by the expert, and there's other rules. Rule 11 says that anything you sign, you're signing under penalty of perjury. Essentially, they don't use those words, but you're signing it to be true. So functionally in federal court, your report is an affidavit. The difference is in an affidavit, you can only testify about things that you know from personal knowledge. As an expert, you know all kinds of stuff other than personal knowledge. So that's what you get away with in a report.
for a federal trial.
Yeah,
Well,
but
that's
it feels
exactly-
good when you're done, doesn't
Huh?
it? It feels good when you're done,
Yeah,
doesn't
it
it?
does.
Yeah. I've had
No,
that.
you lie awake, what did you miss?
Well, that's right.
Yeah.
And in those circumstances where you're required to prepare a report, again, depending on the judge you get, some of them read that report very narrowly and say, if it's not to the letter in that report, oh, it sounds like you're going beyond your report. Sometimes the judge will say, no, I think that this one sentence here introduces that subject, he's simply expanding on it, but within the confines of what he meant in that one sentence. You'll get judges that are a little more nuanced, but you'll sometimes get a judge that says, nope, it's not in the report. And sometimes the defense experts are really, or defense attorneys are very clever. Oh, Your Honor, it's not in his report, and they'll just keep popping up. Like a little, like a jacket about, not in your report, Your Honor, not in your report, Your Honor, and then you have to scramble really quickly. My God, where is it in the report? And you have to say, oh no, Your Honor, it's right here. And they go, oh yeah. So it's a very fast game of trying to catch the expert and the lawyer. Do they really know what's in the report? You're right.
On that point, I wonder if it might be helpful for one of you to talk about, in state court, especially in civil matters, the process by which you disclosing who your expert is, what their qualifications are, what the scope of their testimony is, because that process happens obviously before the judge gets involved. But one of the objections that can be made at trial is, Your Honor, this was not disclosed to us in advance. It's kind of a related objection to the one that you indicated, which is important. So maybe you could talk a little bit about that.
It's 2034, and I was just looking prepared all my codes here. And the other thing, I talk about this at all these meetings, the other thing that I think everyone will really find helpful, it's free. The Federal Judicial Center has these manuals. You don't have to buy it, they're online. They're free, they're terrific. Obviously, I don't use mine at all. And the great charm of these is it's almost a cookbook, not quite. It would be really nice if it was a recipe. Your opinion should say da-da-da. Not quite, but for instance, on the reference guide to medical testimony, there's a little flow chart that now I won't be able to find. Here it is.
Yeah, there it is.
Here it is, the flow chart. And whenever we put on, and Joe's been through this crucible, whenever we put on a medical expert, first off, his report refers within the first paragraphs to the scientific reference manual on the Federal Judicial Center's website. This is published by the United States government. What could be better? And the expert says, I looked at it and I used it as a guide and a template for how to report to you how I went about my work. And then he talks about the contents of all the little boxes in the checklist. And when we're going through his qualification, we put that up on the billboard, and as he's talking, Brian or I walk up to the billboard and point at it, and we haven't lost one yet. So these guides are ridiculously useful. I strongly recommend them. I've shared with you the website. It's the easiest thing in the world to go to the Federal Judicial Center. In fact, I did it last week, and I circulated to Tim some statistics about how many experts are used in average in a civil case, pushing up to 3, I think, on each side. So the statistics nationwide are that you guys are very, very much in demand. That's good. It's a growth industry, and it's showing no sign of abatement. You're indispensable to what we do. So the question that I was getting around to answer is the expert witness, which used to be one code section, now it's about 20. There's an exchange procedure in the Code of Civil Procedure for state court that defines the timing and the content of expert disclosures unless modified by the court, and they almost always are modified by the court. But it tells what the expert has to include, and the way that we do it in state court is I do a declaration. I identify who my experts are going to be, what I anticipate their subject matters are going to be, a narrative of the qualifications of each expert, a representation that he has agreed to testify, and that I have noticed people kind of slip on that. They don't always call the expert and ask for permission. And we should protest that. And a representation that the expert will be sufficiently familiar with the pending action to submit to a meaningful oral deposition concerning the specific testimony, including any opinion and its basis that the expert is prepared to give at trial. And then we have to identify the hourly rate. So I'm trying to describe your anticipated testimony, and my job is to describe it as expansively as I can get away with, so that when you and I finally sit down and hone in on the ultimate opinions, I haven't left you hanging out over the edges. It's the lawyer's job. It's our job. Tim?
Yeah, I just want to go back to the Rule 26 report. There's been times when the reports have been written, and I may get some documents or reports in prior to my deposition, and I come up with some additional findings. And they always ask me, do you have any additional findings other than what you have in your report? And I would, 80% of the time, I would say yes, and give those findings in my deposition. That can still be used in court, is that correct?
Yes, because Rule 26 on the disclosure of expert testimony, Rule 26A2E sub something, says the parties must, not may, but must supplement their disclosures when required under Rule 26E, and Rule 26E is when, tells you when and how, the sequencing. It tells you exactly how you go about supplementing an expert report. And you want to be hip to that. You want to be calling the lawyer and saying, okay, I got to do a supplement. The judges don't want to see as an ambush. They don't want to see Tim sitting on 26 depositions he got somewhere else and walking into court and saying, well, they just don't want an ambush. So having done a good faith effort to disclose, in my experience, judges appreciate good faith pretty much anything. I don't know if that's been your experience, but if you're doing your best to be transparent, you should be okay.
And can we ask Judge Frimpong to comment on a few more questions here? One is that the opinions must pass legal muster of the expert and be viable in the state, and that the expert and attorney should know the local court rules, and the attorney must know the local law and provide guidance to the expert. Would you like to comment on any of these topics?
Sure. I think that's part of what I tried to cover in the opening. I think what's interesting to me, because I've never spoken before a group of experts, is a lot of what you're concerned about, in my view, and I think Brian made this point, the attorney is the one who needs to be concerned about. So the attorney is the one who needs to understand what the appropriate rules are in terms of the disclosure and identify that for you, so that you can prepare whatever needs to be prepared. I gave what the law is with respect to California State Court and the trial judge's role as a gatekeeper. It is obviously slightly different in federal court, and so if you're in federal court, the attorney that has hired you, obviously they have a responsibility to be aware of the federal standard and make sure that the opinion you're giving and your methodology and all of that complies with what the federal court judge will be looking to do. On a related note, the other thing that I think as a judge I look to when I'm starting a case, and I imagine the attorneys look to, if it's a jury trial, is I look at the jury instructions. Because in the same way that we talked about the disclosure before trial of the experts' reports and scope, that is kind of a little bit of a boundary for the expert's testimony at trial. Similarly, the whole purpose of getting evidence before the jury is for the jury to decide the case based upon the elements which are set forth in the jury instructions in a civil case or a criminal case. So if you are trying to get in an expert to prove something which has nothing to do with the elements that need to be proven, that's going to be likely an issue for the judge. So the judge is I'm certainly looking at, well, it's an XYZ type of a case, the prosecution needs to prove these points, the defense, if they're making a self-defense, these are the elements they need to prove. Everything needs to go into one of those boxes. Similarly with the civil case, so that's kind of another way to think about how what the expert is going to be permitted to testify on is circumscribed, because that's what the instructions are, what the jury is told this is how you should decide the case. These are the things you need to focus on. So all the evidence will focus on that as well.
About expert opinions being admissible in one state but not in another state.
Right. I can talk about that generally, although these two might also jump in. Each state has its own body of law in terms of both the general question of what role the court plays in terms of gatekeeping, and that may differ. California is unique. And then there's also probably a body of case law about the specific area. So for instance, I used to do a lot of trials concerning driving under the influence. There is a body of state law concerning expert testimony on alcohol and blood and that kind of thing, which may differ. There may be other states where they've made other findings about what experts can testify as to, or even Betsy mentioned the question of what's considered novel or new. That probably also may vary from state to state. There may be some states where this particular technology or this methodology, it's been used, the courts have determined it's not novel, any expert can come in and testify as to that. And there may be other states where it's still considered novel or new. Or even, there are obviously, as we know, certain areas of expertise that have become discredited over time. And that may differ from state to state. There may be some states that are still using XYZ, and it's not considered reliable elsewhere.
Okay, one state-to-state variation in the job of an expert that is critically important is the burden of proof. Different states have different burden of proof, and the expert, when he's offering his opinion testimony, will usually express that opinion in some form of a level of conviction. Like, I'm testifying based on my knowledge, training, experience, and all the facts in this case, that more likely than not, this ABC happened or didn't happen. Or that's one way to express it. Some states are what are called but-for states. In other words, you must express your opinion. But for this factor, this wouldn't have happened. Or but for this factor, that would have happened. So they're called but-for states. Some states are what are called substantial factor states. It's a different way that you express your ultimate opinion. The ultimate opinion of what that lawyer is really asking you to handle, because that's what the case turns on. So you want to make sure you understand, if you're in California or in federal court or in a different jurisdiction, what is the burden of proof for your ultimate opinion? Is that state a but-for state or a substantial factor state? Because it's enormously different in how the cross-examination will be handled. And these concepts are incredibly elusive. Even judges and appellate courts get them all bollocksed up as to are they really different terms, or are they the same? Some courts say one term is subsumed within the other, whatever that means. So, but it really is important that you understand that for the jurisdiction you're in, because I've not had it happen to me, but I've had other lawyers have a raft of experts prepare expert reports and give that deposition testimony on the ultimate opinions they have, and they expressed it to the wrong standard. They all said, well, this was a substantial factor in causing or contributing to this outcome, and the judge says, well, that's very interesting, but we're a but-for state. And what do you do then? You're out. So this is kind of fundamental, really important to know. And then once you know what it is, do you understand what that term means? Because the lawyers will spend hours taking that phrase and they'll turn it inside out, and they'll examine it from every specific way with you until they can catch you in a way that you go, oh God, are you saying that but for this would have never happened? And you have to think about it. Is that really what I'm saying?
He's trying to scare you.
No, I mean, these are really important. These are the how-to things that really make a difference.
It's the lawyer's job, and the reason we're telling this story is that Brian had a stable of stunningly good experts who are working for the Nuclear Regulatory Agency and so on, and they rendered opinions that passed muster all the way up to the U.S. Supreme Court in a Price-Anderson case in Washington. That same group then tried to express the same opinions in the 10th Circuit in another radioactive emission case, and they were excluded because the lawyer who had come from Alabama, I think, he was an
Colorado.
Alabama lawyer practicing in wherever you said.
Colorado.
He was practicing in Colorado, but he came from Alabama, so I don't think he realized that Colorado was not a substantial factor state. So he told all these wonderfully qualified experts, some of whom were the toast of the U.S. Supreme Court in one opinion or another along the way. He told them, just give me the same opinions. And they did. And these are opinions that had previously been admitted, passed muster, and went to a jury. But in Colorado, in the 10th Circuit, they failed. They failed. And it was a blow to the lawyer, it was a blow to the clients, and it was a blow to all these experts, because that's what you all want. You don't want to be excluded. It doesn't look good on your resume. You want to be admitted every time. And that was not the expert's fault. It was the lawyer's fault. And that's what the judge said a few minutes ago. Everything we're hearing today, it's our job, it's my job to sit with you and say, and Brian and I actually do what you said. We start with the jury instructions. You know, I got a case in California, but for a New Hampshire plaintiff, which happens in pharmaceutical. I order from Lexis the New Hampshire jury instructions, so I can be damn sure that my experts all testify to the standard and that they will be expected to in front of a jury. And that's my job. I don't want you guys to be afraid of what you're doing, because we're telling horror stories. These are
Have any of you, I know we had talked about this on the call and then I totally forgot to do it. I wasn't sure whether a lot of experts have ever seen jury instructions. So that may be something that maybe we could try to pull it up online. I'm trying to quickly think off the top of my head if I could give an example, but because I know you come and you testify and you leave, and what's important to note is at the end of the case, what the lawyer is going to be doing is the lawyer is going to be trying to convince the jury that they have proven their case according to the instructions that that were given. And so it is, I do think it's something that's probably helpful for you to know in your given field, the general, the context of what the jury instructions look like. I'm trying to think of what was the last, yeah.
Cassie, I think they are online. I think they're on the.
Yes, you can look them up online. It's probably best if I don't just try to find one here, but let me take an example of, let's say domestic violence. I've done a number of domestic violence trials. The prosecution is going to be trying to prove to the jury instruction is going to say the defendant, let's say it's battery on a spouse. It's going to define what is battery. It's going to say that battery includes any unlawful or offensive touching. It's going to define the relationship that's needed. It's going to, if it's battery on a spouse with an injury, it's going to define what an injury is. And so those are all the things that the prosecution is going to be needing to prove. Let's give a civil example of a personal injury. This gets to the substantial factor issues that Brian was talking about. The plaintiff is going to have to prove that the other side did something, that something caused damage, and then there's a whole definition of what cause is. And that's where things get tricky. Does cause mean if this thing hadn't happened, the other thing wouldn't have happened, or does this mean it's one of a number of causes? So that may be helpful for you to look at.
Why don't we, since we're starting to run out of time, wonder if anyone would like to address what should experts know about the landmark Galbert case in determining the reliability and admissibility of testimony? Anybody like to take that on?
One word, gatekeeper. That's the name of the game. The judge is the gatekeeper. And your goal is if you're testifying on behalf of a party in the case in chief, your goal is to have your testimony be admissible. That means you got past the gatekeeper. That's the name of the game. And if you're testifying for the defense, you want to make sure that gatekeeper, the judge, looks askance at that testimony and says, gee, it's not reliable, there's a gap there. Or, he explained his method, but he sounds like he cooked it up himself. Anything you can do, that's the name of the game.
So I just put up a literally random jury instruction. Just for those of you that have never seen an instruction, so you know what it looks like. At the end of the trial, the judge is going to read a whole bunch of instructions and possibly give a printed copy to the jury, and these blanks will be filled in. But so this is some claim for strict liability for injury caused by a domestic animal with dangerous propensities. And so the plaintiff is it describes what the plaintiff is claiming, that they claim that, my neighbor's horse harmed me, and the plaintiff and the defendant my neighbor is responsible for that. And so it's got a little bit of law. The jury instruction is basically a way to transmit to the jury what the law is in a simple way. This one says people who own, keep, or control animals with unusually dangerous natures or tendencies can be held responsible for the harm that their animals cause to others, no matter how carefully they guard or restrain their animals. And then they tell the jury to establish his or her claim, the plaintiff must prove the following. And so this is what the plaintiff, all their evidence, including their experts, is going to have to go to this. At the end of the trial, they're going to want to say, well, ladies and gentlemen, I proved, 1, that neighbor Bob owned a lion. 2, I proved that the lion has an unusually dangerous nature or tendency. Maybe that's where the expert came in. 3, I'm going to prove that I was injured and that neighbor Bob should have known that lions have the tendency to bite people. Then 4, that I was harmed, and 5, that this just kind of gets to the causation. The unusually dangerous nature or tendency was a substantial factor in causing the harm. So with the lion, if I went into the neighbor's yard and I started poking the lion in the face, maybe I'm not going to be able to prove that it was because the lion is unusually dangerous that I got harmed. Maybe that's something but anyways, just to give you an example.
Okay, so your neighbor's got a lion, and you're gonna sue because the lion injured you. Maybe was the enclosure defective in a way that it was a substantial factor causing the lion to get loose and bite somebody? Or, but for the enclosure, that lion would have never gotten loose. So the substantial factor versus but for may be your claim. Hey, if you'd had a better enclosure for the lion, it wouldn't have gotten loose and come into my property and injured me. So the substantial factor versus but for. So if you get a lion containment expert, like a zookeeper or somebody, says, oh God, you would never put a lion in a thing like that. They can get loose. And but for the way he had that thing confined, it would have never gotten loose. Or the way he did it was a substantial factor. You just don't know because you got to know which state you're in and what they require.
And to Brian's point, if, for instance, you had an expert, so here, the plaintiff is going to need to prove that the lion had an unusually dangerous nature or tendency. And if the expert testimony is to the side of that, the expert testimony is only saying it was as dangerous as all animals are, or it wasn't a nature or tendency, it was I've studied this particular, lion, whatever his name is, Simba, and he's dangerous. Those things are not going to this element. So that's what he was getting at before in terms of the lawyer is responsible for knowing what is it they're going to have to prove in their state and making sure that the expert testimony goes to that. Because the expert is giving great testimony that doesn't go to what the attorney has to prove. It's not helpful and it might be excluded as irrelevant.
That's it.
Generous, and the case law tends to be really generous. For instance, I think in California the case say that I can have a radiologist critique a neurologist, but you don't have to have a doctor in a particular expertise to critique that expertise, particularly in the medical fields. It's very generous, and the reason for that goes back a million years when no doctor wanted to testify against another doctor, and you kind of couldn't get a pediatrician to point a finger at a fellow pediatrician, so you had to get, a urologist to do the finger pointing. So in terms of vetting an expert, I'm looking for someone that can answer these questions, that has the background sufficient to answer these questions, but he can also get that background working on the case. He can do the education while he's working on the case with me, if he has the basic tools to do that. I don't think I could hire a dog catcher and ask him to get educated up on, for instance, shaping a tree, and talking about an arborist's job, but I probably could get an arborist to talk about a lot of different areas that have to do with agriculture and botany.
Brian, did you want to amplify or add anything to there?
Only this, my experience has been, is, you know, I've spent I don't know how many years vetting experts, meeting experts, looking for experts all the time. And when I sit down and I meet with them for that first time and I talk about the case, if they're looking at me and saying, oh, wait a minute, have you thought about this? Oh, wait a minute, and they're engaging me, and they're making me think of things I hadn't thought of. I thought this was an issue, and all of a sudden they're challenging me. That's the guy I want, because now he's thinking 2, 3, 4 steps ahead of where I am in my learning curve, and he's saying, oh, no, don't worry about that. What about this over here? And he's not dogmatic, he or she, I should say, but I can tell they're thinking. That to me is when I go, okay, I've got somebody here I can work with.
Okay, why
I think
don't
we had a
we,
question in the back. You had a question?
It wasn't a question,
Oh,
it was
okay.
a comment. And that is, I always ask, what is the scope of work?
Yes.
And I think you have to keep asking that question, because very often the scope of testimony doesn't match. And so you have to make sure that you keep discussing it, because if they're not informing you of issues that have not been included, or a judge has excluded certain aspects, and you're preparing one way, without that knowledge, it can be deadly.
Yes.
So I always try to keep that dialogue going, even though they get busy, and asking, is the scope of work that we talked about going to match the scope of testimony?
Yeah, that's a really good point, and that'll happen in your cross-examination where they'll try to take you beyond the scope of what you, that's very, it's one of those devious ways to kind of either get some new testimony out of you, fish for information, and, the other expert I was telling you about that's so clever about making sure he understands everything, he'll sit there and think about it and say, I think that's beyond the charge of what I was asked to do.
Or if I had an opinion on it during deposition and the judge has excluded it, I need to know that
Yeah.
before I get
Yeah.
on the stand.
Yeah, you have to be careful about, even though you may know, you have to think about, do I really want to answer that? Is that really within my charge? And if it's not, just say, that's not what I was asked to do.
I don't want it to be scary for you. That's the one thing that always spooks me when we're up here is, don't do this, you're gonna get through. It isn't that hard. What we're trying to do is give you some pointers for something that you're already really good at. You're at these meetings because you're really good at it, but we're trying to bring to this room, you're interfacing with us, what you're selling your business to us and people like us, and we're trying to buy from you because we're trying to sell what you have to offer to a jury. It shouldn't be impossibly hard, and we don't mean to make it sound like it's impossibly hard. What our job up here is to do is to try and make it easier for you, because it really is very logical. What you're all doing is really very, very logical. It's what you do, it's your expertise, and you know how best to express your opinions. Our job is to paint the lines on the road, and your job is just to stay in the lines, and everything ought to be fine.
Judge Frimpong?
Sure. I was trying to look for my concluding slide, but I think I would say, and this is what I hoped to convey, 2 things today. First of all, don't worry about it. Don't worry about it at all. When we talked about preparing, Diana made clear that there was a lot of concern out there about Sargon and Sanchez, and so I think that's a takeaway that you want to make sure that you understand that the boundary lines that those draw for you. And then just understanding the role of every player. I think Brian has done a great job of explaining what is opposing counsel trying to do when he or she is asking you questions. And then I think it's helpful for you to know what the judge's job is. As the judge, I am not here to decide whether your opinion is persuasive, whether it's good, whether your side should win or the other side should win. The law tells me that certain things should go into the box that the jury looks at and certain things should not. And so you want to make sure to stay away from things that the other side is going to be able to argue to the judge are speculative things that there's not a logical flow from what you relied upon to your conclusion, or your methodology was something that is, nobody else relies on that, or nobody else relies on those types of studies, that's not to say don't do it, just know that those are going to be flags to the judge and the other side as to what should be excluded. And moreover, and this probably doesn't apply in any of your fields, because your fields are pretty technical, but the judge is going to be very wary of allowing somebody to testify with the label of an expert on something that jurors have common knowledge about, and something that in some ways just not going to be helpful to the jury. That kind of gets to, as I mentioned, the jury instructions. If it's just kind of to the side of the topic and is going to be confusing to the jury, the judge is not going to allow that. So in short, I would say just kind of keeping in mind, and your attorney should focus you on this, what you're trying to get. The end goal is the attorney wants to get certain information before the jury to convince them that they've met all the elements, or that the other side hasn't met the elements, and the judge is there to make sure that things that shouldn't go before the jury don't go before the jury. So yeah, I hope that's helpful.
Thank you very much, Brian.
One bit of advice: you're in more control of the process than you think. Just let that settle in.
That's true.
Indeed.
He's that guy.
Very true.
He's that guy.
That's it.
Does it need 3 minutes?
Well done, well done.